of Information will look at doing that in short, which as consequential to the amendment to the Anti-Gang Act. We also had a discussion on the police requests for extended pre-trial detention. We did not come to any conclusion, and that matter seems to require some more exploration, but the matter was discussed. I think I don't have much more to discuss on that issue. As I said, there was no conclusion. The consensus seems to be not to provide the police at that time, but there's still some concern that in the specific gang case, the police need to examine the processes when they after they detain them. And I think the opportunity will have to arise for some further discussion. Whether the consensus, some do feel that 14 days will be too long, certainly, and even 7 days. But I do think we have significant numbers involved, although we have had some charge is laid against some gangs. There are issues to be raised and looked at. But I won't reopen again. AG?
Chairman, it was my understanding that there was somewhat of a consensus that the time may need to be enlarged, just so that the period specified in the request from the JCF has not been justified. And so they are to provide additional information,
okay.
But that there may be an enlargement of the time to facilitate the investigation of a certain number of suspects,
concluding investigation
above a certain threshold.
Although I do think the chairman read the mood of the committee well. He was accurate in reading the mood of the committee, and his comments reflected that.
We'll have to look at that separately. Now, I think we're going to have the Ministry of National Security do a presentation on what we have termed in the initial stage an extended control order. Well, not a control order, a watch list, feasibility of a watch list for designated gang members.
Thank you, Minister. Good afternoon, members of the committee. There is supposed to be a PowerPoint presentation that is coming up on screen. So my name is Rohan Richards. I'm the Chief Technical Director in the Ministry of National Security. And the presentation this afternoon will outline the proposals for the creation of a watch list under the amended Anti-Gang Act. And I want to point out that these proposals were developed based on consultations with our colleagues from law enforcement within the Jamaica Constabulary Force, as well as MOCA and the Jamaica Defense Force as well. The content of the presentation will go into somewhat what we term pre-conviction, post-conviction, and then outline some various recommendations. The watch list as we envision it is essentially will essentially be established to maintain a, for want of a better word, watch list of persons suspected, accused, and or charged for offenses under the Criminal Justice Suppression of Criminal Organizations Act, to maintain a registry of persons convicted for offenses under the Act, to enable the imposition of some amount of special conditions or restrictions on those persons who are also suspected, accused, charged, and or convicted for offenses under the Act, and of course to enable better management and supervisions of those persons who are charged under the Act. for pre-conviction,
Hold on. What I'm reading there, you said just charged, but it said suspected, accused. So which one am I to go? What is on the
screen
slide, or what you're saying? Are you just shorthanding the slide?
I'm trying to go as quickly as possible.
No, but it's important. It's a different thing to better manage and supervise somebody who is convicted, for example, or charged, than someone who is only suspected. So I think you need the precision in what you're saying, because you're really two quite different things.
So the
items 3 and 4, I already have opinion from council that they're unconstitutional.
So if you allow me to do the presentation, I'll show you where we present the options for the pre-conviction and those for the post-conviction, and some options that we're outlining to the committee for consideration. So I'll repeat the last point because we speak to better management and supervision of persons suspected, accused, charged. Those will be pre-conviction and or convicted of offenses under the Act.
Just for clarity, what is the distinction between the accused and the person charged? I mean, the suspect is a pre-charge stage, but what do you mean by categorizing separately someone who is charged and someone who is accused?
I think we refer to the same. We just picked some language which we...
So properly there are two categories, those that are suspected but not yet charged,
right,
and those who have been charged.
That's correct.
But not yet convicted.
Correct.
And then you have the convicts.
Yes. So for the persons suspected, accused, or persons accused or charged for offenses under the Act should be included. Suspected or charged, we want to include those on the watch list. And the purpose of the watch list is really to enable the monitoring of these.
Just before I proceed, those people would have to be the members of criminal organization.
Members of criminal organization, that's correct, sir. So the purpose really is to enable the monitoring and or imposition of certain restrictions on those persons in a pre-conviction scenario. So we're going to be outlining 3 proposals for consideration for the monitoring of these alleged gang members and the creation of the watch list. The 3 proposals we're advancing are: 1, which is in keeping with the current provisions of the Bail Act, and I will set out those conditions in preceding slides. Similar provisions as stated in Section 14 of the Terrorism Protection Act. Or the 3rd are provisions that were proposed under the Law Reform Zones of Special Operations, Special Security and Community Development Measures Bill, namely clauses 2J to 2X, and these were actually proposed as consequential amendments to the anti-gang bill, but they were not included.
Sir, I'm having a little, Chairman, thanks. I'm having a little difficulty here because my recollection is that the Bail Act doesn't deal with suspects. So I don't know how you're going to make a section of it applicable to that which it does not deal with.
Do you have further proposals on the matter?
It appears, and you may clarify if I'm wrong, that you are looking at your proposal and almost conflating it with what is provided for, but really is what is to be provided for should the proposal be accepted. Right, because currently there is no provision in our law for pre-charge bail. Bail is granted to persons who have been charged with an offense. So, if you're talking about suspects who are below the charge stage, then the provisions, as Member Knight say, of the Bail Act do not apply at all.
Well, in this instance, we're speaking of persons who are actually charged. So, which is why I really have to go back to the suspected, accused, or charged.
Once you are charged, you're no longer regarded as suspect, and the DPP will tell you that a different set of rules apply, even in terms of what you can do from an investigative standpoint. Past a threshold, and different rules would apply. If the fundamental principles have been confused, then you may have challenge with the rest of the presentation, if the basics, but let's see what comes.
Okay. So let me try as best as I can to present the options which we have outlined in the presentation. For option 1, we're looking at it as a condition of bail. Section 6 of the Bail Act outlines several conditions when granting bail to a person charged with an offense, to include surrendering their travel documents, informing the court of his intention to leave the island, reporting to the police at specified dates and times, and or requiring these persons to stay at a specified location between specified hours as required by the court. Additionally, Section 6, subsection 6, allows for additional conditions to be imposed upon application by a prosecutor or a police officer. And just to reiterate, 6.6 actually states that where a court has granted bail in criminal proceedings, it may, on application, by or on behalf of the person to whom it was granted, or by the prosecutor or police officer, vary the conditions of bail, or where bail was granted unconditionally, impose conditions. Section 7 requires that the court or police officer makes a record of a decision of bail. Continuing with the provisions for option 1, we are proposing the inclusion of the following in addition to what is required in the Bail Act for the purpose of the Anti-Gang Act: that the information collected under Section 7 of the Bail Act should also be included in the watch list, and that will actually formulate the watch list. And if the judge is satisfied that the accused...
May I just say, Chairman, we're being mixed up, you know. We're mixing up. You need to clarify. If the person is charged, there's no problem, okay? But one gets it's very clear. But the impression I'm getting now, you're mixing up pre-conviction and pre-charge. You see, so what I really would like to know, are you saying what you're dealing with here, a person who have not been charged?
No, we're dealing with persons who have not been convicted.
Yes.
But these provisions already exist for persons who have been charged. These provisions are already in the law for persons who have been charged. They're in the Bail Act.
Let me ask a layman's question. Sorry. My understanding is that he's suggesting this is dealing with people who have been charged, and when they are being bailed, the court can request to put them on a watch list. That's pretty straightforward.
No, but you see, the point about it is, once you're charged, you can impose any amount of conditions. So that's not a difficulty.
Are you trying to provide further specific conditions? And if so, if you go directly to that, it may assist.
The pre-conviction option 1 contained. Option 1 is suggesting that it started with bail and outlining what will be available under bail. I don't see anything to suspect there. Because bail comes with a charge. Am I right? So what he's proposing is that on a condition of a bail could be to be placed on a watch list. Am I right?
That's correct.
Yeah. The suspect, there's nothing on the suspect here yet. I will wait and see what comes on the suspect.
Well, I don't understand, if there's something specific about this watch list. I don't know. Because, for example, under the Bail Act, the person can be, put under curfew, report to a bail center, report to the police station, etc., etc. And there's no better place, for example,
if I look at the follow-up there, remember,
at a police
the special
station.
condition being outlined, the follow-up, not to assist that 1, 2, 3, 4, 5, 6 conditions. There are those not.
You know what the difficulty is? We can't read it from here.
No, but the judge can impose all of these.
She can impose all of them already.
I'm suggesting that you'd like to see specified in relation to persons who are charged with gang offences, some specific conditions that the court should consider as a condition of granting bail. Even though the Bail Act allows a very wide range, it provides certain things, but then it allows additional conditions, varied conditions, and so on, as you just read 6.6. You are suggesting that in the context of gang offences, there should be some specific conditions that are in the law that the court may choose to impose or not. Well, he has, I think they're listed in this. Yeah.
Yeah, may I understand the condition required is for members of gangs who are charged.
You don't know if being a member of a gang is a criminal offense. Until you're convicted, you're not a member of a gang.
Chairman, I'm having a little difficulty before we go further down the road. And it does appear that there are some foundational challenges with the presentation. I would like to think that an attempt is being made to provide a regime for persons who are suspected of offenses but are not yet charged. A separate regime. And the question that will have to be answered is what constitutional construct we would situate that in. And what would be the overriding reason, whether it relates to members of criminal organization or otherwise, but more specifically in the context of this committee meeting. Right, what is the overriding reason for that separate construct for persons who are suspected of offenses but are not yet charged? And then you're looking at revising the construct for persons who have been charged but not yet convicted, and then a third construct for what happens post-conviction. Right.
A good summary.
There's a problem here. There's a problem here, if you may yield.
Sure.
Thanks. I know that they spent a lot of time working on this presentation. That's how they operate at the Ministry of National Security. I know that. And maybe what has happened is that, and I am guilty, please, I admit guilt, of cutting you off before you have really made your presentation, which is wrong and unkind. But perhaps what was necessary was for us to have had the presentation in writing, because I didn't get it in writing. And so we would have been able to, prepare ourselves as to what is to come and then await your presentation. Minister, Chairman, they need to be given the opportunity to make their presentation. On their behalf, I ask that you allow them to give us
their presentation and give us a document.
No, give us a document and return. Let's read the document, because they're referring, for example, to statutes. So we need to familiarize ourselves with the statutes, having regard to the presentation.
In fact, it would be useful to have Section 14 of the Terrorism Prevention Act set out in your document, so we can remind ourselves what it says. And perhaps when you circulate it, you could have in mind the conceptual framework in our law, which differentiates between persons who are just suspects and have not been charged with an offense, persons who have been charged and have a right to bail unless the court feels otherwise, on clear ground set out in the law, and those who have been convicted in a court of law.
Noted, sir, and we appreciate that, and we will do that with the chairman's guidance.
Yeah, we are. Oh, let me find out our next sitting. I think we can have one more sitting for the year. You have a space?
Next week, maybe we can put a time.
When was this? When is it? No. No, we're having the 12th. There's nothing.
No, we have two for last week when you said you told me you'd be traveling.
We can have one more sitting for the year next week, Wednesday. That's bad for you? That's it. Next week is. No more for this year. You know, Mr. Bunting only came for the first meeting. He'd love to have us for our sitting before.
I've only missed one.
Eh?
The 13th.
Yeah. All right. You look like next.
But in the meantime, the document could be circulated.
Yeah.
We have a normal mandate submission. It's quite long. Ooh. I think that remember in trying to tie up the submissions on this side of the year, because in the new year, if we get this one, we're going to have a lot of long, tedious. Members, I was suggesting that even a short sitting is not long. We'll circulate the documents. Let's tie up the submissions this year and next year, because I think the post-submission discussions are going to take quite a bit of time and other technical details, so it will make some sense. It shouldn't be long. We give an hour next Wednesday. Wednesday, the 12th. Oh. Two o'clock on Wednesday for an hour to get the minister's submission, but it must be circulated before the weekend.
Chairman, I understand the anxiety, but I think we have to look at this thing.
It's already scheduled for next week Wednesday.
No, it is not.
It is. Well, it's in my diary for next week Wednesday.
Yeah.
At 2.
Well, let me put it this way. To assemble all these people for 1 hour, you know the cost? You know the cost?
We'll do it for the wet.
All these people for 1 hour?
No, the schedule for the 12th was set at the very beginning.
With gas price at 100 and holy per.
Right. It's good, valuable manure for a very valuable piece of legislation. But no, it was set at the very beginning of the sitting that would meet on the 12th. There was some ambiguity.
But I never understood for 1 hour.
No, it don't be 1 hour. I just said a regular meeting, but I was, because of your concern, we're yielding to you that we may make it shorter than usual, but we have the document from the Ministry of National Security will be circulated, and there's a short submission from the Norman Manley Law School. We could conclude those, and we'd go into January with all the post-submission discussion, which I know will take some time before we get back to Parliament. We have enough lawyers to take us a while in that section.
28 people on that side.
Right.
Right, I'm just seeing some clarity on behalf of the JCF as it concerns the pre-charge detention proposal that we had submitted, because at the last meeting last week there was some robust discussions about the possible processes and safeguards that could be put in place. So it would not just be for the police to detain its carte blanche for 7 days. And I believe it was indicated that we will be working on a proposal just to outline the processes that could be put in place. For example, having Justice of the Peace review the detention on an automatic basis. And I had in fact started working on that proposal, so I just wanted some clarity as to whether we should continue in that regard and then submit same for further consideration.
Yes.
Thank you.
Come in the new year.
Yes, Chairman. What I understand is that a proposal is being made to look at a regime for suspects and pre-charge, how to deal with persons who are not yet charged in terms of their detention and preparation until such time. So, short answer, the Chairman says yes.
No, you conclude that, but next week we'll ask him to circulate the document, and we'll have Norman Manley come in, and that will be it. We should be able to conclude that. Thank you. 10 to 5, we adjourn until next week, 2 o'clock. Eh? Huh?
Today? Submission is here.
Submission is here, but they're not here.
So you would just remind us to read it in preparation for next week.
Yes, sir.
I'm advised you read. So that will be for this evening. We'll adjourn until next week at 2 o'clock, and we hope we can conclude all the submissions then. Engineer, thank you very much, gentlemen. We won't wish you a good holiday yet. We won't give you the holiday till next week. I have to thank the members from the telecom companies, and we'll see you next week. It's good to have had you, all right? But I'm sure there'll be further consultation. All right?